a Florida courtroom full of trained lawyers, seasoned prosecutors, veteran legal analysts, and experienced judges, people whose entire profession is built around arguing, objecting, spinning, and responding to absolutely anything thrown at them when completely silent for 45 full seconds, not a brief pause, not a moment of surprise, quickly covered by the usual courtroom noise. 45 seconds of complete, total, deathly silence in which not one lawyer moved, not one objection was raised, and not one single person in that room could find a single word to say. And the thing that caused it was not a dramatic witness confession or a surprise legal argument. It was a video, a surveillance tape that Donald Trump and his entire legal team had allegedly spent months desperately trying to make disappear forever. That tape showed a former president of the United States on camera with audio, with a timestamp, giving explicit instructions to destroy the very evidence that federal law had just ordered him to preserve. Hours after receiving federal subpoenas demanding that everything be kept intact, Trump allegedly ordered his staff to wipe the servers, erase the files, and make the security footage vanish. The camera he tried to erase was still recording when he tried to erase it. And when Judge Arthur Engram played that footage in open court on February 14, 2026, the defense that Trump's lawyers had spent months carefully constructing collapsed in real time in front of everyone watching. But here's the part that makes this story genuinely extraordinary, and the part that mainstream coverage has completely failed to connect. The servers Trump allegedly ordered wiped did not just contain security footage. According to prosecutors, those same servers contained records linking his classified documents case directly to the Epstein files that were being released at that exact same moment, and the person who can confirm both connections is not a hostile witness or a political enemy. It is the woman Trump himself calls his most trusted and loyal person, and she already confirmed it on camera in her own interview without even realizing what she had done. Let's start with the numbers, because even before the surveillance tape was played, even before the courtroom fell silent, even before the inner circle began providing the connective tissue that prosecutors needed, the raw scale of what Donald Trump is facing legally right now is unlike anything in the history of American presidential politics. 40 felony counts, that is the number of separate criminal charges in the Florida classified documents case alone, not civil allegations, not regulatory violations. 40 individual felony counts in a single federal case built around the retention of classified national security documents at his Mar-a-Lago estate, documents that intelligence officials have described as among the most sensitive materials in the entire United States government. And Florida is just one of 3 active criminal jurisdictions pursuing cases against him simultaneously. A fourth was considered likely at the time of this recording. Trump was not present in the courtroom when the not guilty plea was entered on his behalf. His lawyer spoke for him. His personal aide, Walt Nauta, stood in the same room and entered his own not guilty plea on his own charges in the same proceeding. But here is the specific detail in the updated indictment that transforms this beyond a simple classified documents case. Prosecutors did not just allege that Trump improperly retained classified materials. They alleged that he and his staff actively and deliberately attempted to destroy security camera footage before federal investigators could seize it. This is not a question of paperwork mishandled carelessly or documents stored in the wrong location by well-meaning staff. This is an allegation of active, real-time, deliberate obstruction of federal justice by a former president who had just received unambiguous legal notice that all evidence must be preserved. The law and order candidate fighting for his freedom, sending lawyers to courtrooms he will not personally enter, and a surveillance tape waiting in a Florida courtroom that was about to make everything significantly worse. There are moments in legal history that attorneys study for decades afterward, moments when a single piece of evidence cuts through years of carefully constructed narrative so completely and so permanently that the entire architecture of a defense simply stops functioning in front of everyone watching. February 14th, 2026, in a Florida federal courtroom was one of those moments. Judge Arthur Engram ordered the surveillance footage played in open court. This was the tape that Trump and his legal team had desperately and repeatedly tried to suppress, delay, and keep hidden from public view, the tape that prosecutors had fought through months of legal proceedings to present, the tape that Trump's lawyers had argued against, filed motions against, and constructed elaborate legal arguments to prevent from ever being seen in that room, and then it played. The footage shows Donald Trump explicitly ordering staff to delete security camera recordings and destroy evidence, not suggesting it ambiguously, not implying it through coded language, explicitly ordering it with his own voice. On camera, with a timestamp that places the instruction in the hours immediately following the issuance of federal subpoenas demanding that all records be preserved without exception. Trump's public position had been unwavering and consistent for months. He cooperated, he handed over the tapes, he did nothing wrong. His lawyers have repeated versions of this claim in press conferences, in court filings, and in television appearances. The narrative had been built carefully, repeated consistently, and delivered with complete conviction. The courtroom watched the tape, and then the courtroom went silent. 45 full seconds. Counted out loud, that is an extraordinarily long time in a room full of legal professionals whose entire function is to respond to everything. Not one lawyer moved. Not one objection was filed. Not one alternative explanation was offered. Just a cold, time-stamped, undeniable image of a man on camera doing the precise thing he had publicly and repeatedly sworn he had never done. The timing is the detail that transforms this from a damaging story into a potentially catastrophic one. And once you understand the precise sequence of events, the word coincidence becomes completely impossible to apply. Federal subpoenas are not ambiguous documents. They arrive with explicit, unambiguous, legally binding language requiring the immediate preservation of all relevant evidence without exception. When a federal subpoena lands, destroying evidence does not simply strengthen the underlying case against you, it creates an entirely separate obstruction of justice charge that prosecutors can pursue completely independently of the original investigation. Trump received the subpoenas, and hours later, not days, not weeks, not after consulting lawyers and misunderstanding the legal requirements, hours later, he is on camera ordering Walt Nauta to destroy the servers, erase the files, and make the security footage permanently disappear. According to prosecutors, these were not vague suggestions open to innocent interpretation. These were explicit criminal instructions delivered directly, confidently, and on camera by a man who had just been legally notified that everything must be preserved. The maintenance worker allegedly asked to physically delete the security footage did not stay silent. The very person Trump asked to help destroy the evidence became part of the evidence trail that prosecutors used to construct and strengthen the obstruction case. Trump's counterclaim that he personally and willingly handed the tapes over to investigators now sits in a federal court record directly alongside the surveillance footage of him ordering those same tapes destroyed. Both claims cannot simultaneously be true. The jury that will eventually decide this case will be watching both of them. The subpoena arrived with a clear legal deadline. The destruction order came hours later, and the camera recorded everything. Now, here's the connection that most mainstream coverage has completely failed to make, and it is the connection that transforms this from a straightforward obstruction case into something significantly more complex, significantly more deliberate, and significantly more damaging to Trump's legal position. The destruction order did not happen in isolation. It happened at the precise moment the Epstein files were becoming public, and the servers Trump allegedly ordered wiped did not contain only security camera footage related to the classified documents case. According to prosecutors, those same servers contain records that could establish direct connections between the classified documents Trump retained and the Epstein files being released simultaneously. Think about that timeline with complete honesty. Federal subpoenas arrive demanding preservation of all evidence. The Epstein file release begins generating public attention and serious legal scrutiny across multiple investigations. Hours after the subpoenas land, Trump is on camera ordering the destruction of the precise servers that prosecutors believe tie these two separate scandals directly together. This is not a coincidence that prosecutors are willing to dismiss. The timing does not suggest panic from a man caught off guard. It suggests calculation from a man who understood exactly what those servers contained and exactly why they needed to disappear before investigators could access them. And here is what makes the timing even more legally significant. A defendant who destroys evidence related to one investigation faces one obstruction charge. A defendant who destroys evidence connecting multiple simultaneous investigations faces something categorically more serious: a conspiracy to obstruct justice across parallel proceedings. The servers are gone, the destruction order is on tape, the timing is documented, and the person who can confirm exactly what those servers contained is still working in the White House right now. Now let's talk about the person who has quietly become the most consequential figure in Donald Trump's entire legal situation. Not a hostile witness, not a political enemy, not someone with an obvious motive to damage him. His own chief of staff, the woman he has publicly and repeatedly called one of his most loyal and trusted people, Susie Wiles. According to documents unsealed in March 2026 by the Department of Justice and the House Judiciary Committee, Susie Wiles was physically present aboard Trump's private plane when he pulled out and openly displayed a highly classified military map. A document so extraordinarily sensitive and so tightly restricted that only 6 senior officials in the entire United States government were authorized to view it. 6 people in a country of 330 million cleared for this specific document. Susie Wiles was not one of them. She did not have the clearance. She was not on the authorized list. She saw it anyway because Trump displayed it in front of her on his private aircraft in what prosecutors describe as a deliberate and knowing exposure of classified material to someone completely unauthorized to receive it. She witnessed it. She was present. She cannot unsee it. And the reason this matters so enormously to prosecutors is precisely because of who she is. This is not an accidental bystander. This is the person running Trump's White House, the person who managed his 2024 campaign, the person he trusts above almost everyone else in his inner circle. Her presence on that plane is documented. Her witnessing of that classified map is documented. And what she knows about everything connected to those servers is about to become the most important question in this entire case. Now let's talk about the person who has quietly become the most consequential figure in Donald Trump's entire legal situation. Not a hostile witness, not a political enemy, not someone with an obvious motive to damage him. His own chief of staff, the woman he has publicly and repeatedly called one of his most loyal and trusted people, Susie Wiles. According to documents unsealed in March 2026 by the Department of Justice and the House Judiciary Committee, Susie Wiles was physically present aboard Trump's private plane when he pulled out and openly displayed a highly classified military map. A document so extraordinarily sensitive and so tightly restricted that only 6 senior officials in the entire United States government were authorized to view it. 6 people in a country of 330 million cleared for this specific document. Susie Wiles was not one of them. She did not have the clearance. She was not on the authorized list. She saw it anyway because Trump displayed it in front of her on his private aircraft in what prosecutors describe as a deliberate and knowing exposure of classified material to someone completely unauthorized to receive it. She witnessed it. She was present. She cannot unsee it. And the reason this matters so enormously to prosecutors is precisely because of who she is. This is not an accidental bystander. This is the person running Trump's White House, the person who managed his 2024 campaign, the person he trusts above almost everyone else in his inner circle. Her presence on that plane is documented. Her witnessing of that classified map is documented. And what she knows about everything connected to those servers is about to become the most important question in this entire case. Here is where the Susie Wiles story stops being about classified maps and becomes something that prosecutors describe as genuinely devastating for Trump's legal position. In a recorded interview with Vanity Fair, her own words, her own voice, completely on the record, Susie Wiles confirmed something that prosecutors had been working to establish through months of document requests, subpoenas, and witness interviews that Trump's legal team had fought at every single step. She confirmed she personally read the Epstein file. She confirmed Trump's name appears in it. She confirmed he flew on Jeffrey Epstein's private plane on multiple occasions. She confirmed his name appears directly on the flight manifest. She attempted to soften the admission immediately, saying he was not doing anything awful, providing context, minimizing the significance, trying to protect the man she has loyally served for years. But the words were already out, on tape, on record, impossible to retract. The most trusted person in Donald Trump's entire inner circle had just handed prosecutors a direct, public, recorded confirmation of the precise connection between Trump and the Epstein documents. The same documents being released at the exact moment Trump allegedly ordered the servers containing related records permanently destroyed. She did not intend to damage him. She was trying to protect him. And in trying to protect him, she confirmed the two things that prosecutors most needed confirmed: his presence in the Epstein file and her own direct knowledge of its contents. This is the cruel mathematics of loyalty in a federal investigation. The harder his most trusted people try to defend him in public, the more they confirm what prosecutors need confirmed. The interview meant to help him became evidence against him. Here is the reason the server destruction order carries consequences that go far beyond a standard evidence tampering charge, and it is the reason prosecutors are treating this not as a single act of panic, but as a calculated attempt to sever connections between multiple simultaneous investigations before those connections could be documented. In most obstruction cases, the destroyed evidence relates directly and only to the underlying charge being investigated. The obstruction is serious but contained within one case. What prosecutors are alleging here is categorically and fundamentally different. The servers Trump allegedly ordered wiped on camera did not contain evidence limited to one investigation. According to prosecutors, those same servers contained records capable of establishing connections between three separate lines of inquiry simultaneously: the classified documents retained at Mar-a-Lago, the security footage documenting their retention and movement, and the Epstein connections that Susie Wiles has now publicly confirmed exist in files being released at the precise moment the destruction order was given. This is what makes the timing so legally catastrophic. A defendant destroying evidence related to one case faces one obstruction charge. A defendant destroying evidence that connects multiple converging investigations at the exact moment those investigations begin overlapping paces, something prosecutors treat with significantly greater seriousness. It transforms isolated obstruction into coordinated conspiracy to suppress evidence across parallel proceedings. And the additional problem that cannot be overlooked is this: the attempt to destroy the connecting evidence is itself now connecting evidence. The deletion order is on tape. The timing relative to the subpoenas is documented. The timing relative to the Epstein release is documented. Trump allegedly tried to erase the connections between the cases. The erasure attempt became the most powerful connection of all. There is a pattern that federal prosecutors have observed across decades of major criminal cases involving powerful defendants surrounded by fiercely loyal inner circles. The pattern is consistent, documented, and almost inevitable. Once a case reaches a certain level of evidentiary strength, loyalty holds until personal legal exposure exceeds personal loyalty, and when the most trusted people surrounding a defendant begin providing testimony, deliberately or accidentally, willingly or under legal compulsion, that fills the gaps prosecutors could not fill from documents alone, the case that looked defensible becomes the case that cannot be defended. Trump has built his entire political and personal brand around loyal people. It has been his most consistent public refrain across decades: the people who don't flip, the people who stay no matter what. And here is the devastating irony at the heart of his current situation. His most loyal people are not flipping. They are defending him publicly, standing beside him legally, and maintaining their loyalty with complete conviction. And in doing so, they are confirming the precise elements prosecutors need confirmed. Susie Wiles confirmed the Epstein connection in an interview designed to protect him. Walt Nauta stood in that courtroom and entered his own not guilty plea. The maintenance worker allegedly asked to delete the footage became a documented witness. Every act of loyalty is generating evidence. This is the trap that federal prosecutors understand and powerful defendants consistently underestimate. You do not need people to betray you when their attempts to protect you are providing the confirmations the case requires. The inner circle is not cracking through betrayal, it is cracking through loyalty, and that is significantly harder to defend against because nobody sees it coming until the damage is already done. Let's return to that Florida courtroom one final time, because the 45 seconds of silence is not simply a dramatic storytelling detail, it is the most precise and honest measurement available of exactly what the surveillance tape did to Trump's defense the moment it was played in open court. Courtrooms are not quiet places. They are rooms specifically designed and professionally populated for the purpose of arguing. Every person in that room, defense attorneys, prosecutors, legal analysts, journalists covering federal proceedings, is trained to respond to everything, to object, to reframe, to provide alternative interpretations, to argue against evidence, to find the counter-narrative. When Judge Engram played that tape, those lawyers had already seen it in discovery. They had months to prepare their response. They had the full resources of one of the most high-profile legal defense operations in American history available to them. They knew exactly what was coming, and when it played in that room, they had nothing. 45 seconds of nothing. Now place that silence directly alongside every press conference, every True Social post, every rally speech, every television interview in which Trump has maintained his complete innocence with absolute certainty and maximum volume. The witch hunt language, the political persecution framing, the greatest hoax in American history declarations delivered to roaring crowds, all of that noise, meeting 45 seconds of courtroom silence. The tape does not respond to counter-narratives. It does not adjust based on polling numbers. It does not care about rally crowds or cable news coverage. It simply plays. And the professionals whose job it is to argue against everything found themselves with nothing to say, and that silence was not confusion. It was recognition, and recognition in a federal courtroom is the beginning of the end. Here is the final and most important reason this story matters far beyond the daily political drama surrounding every development in Donald Trump's legal battles, because what is being decided in that Florida courtroom right now is not ultimately about one man's guilt or innocence. It is about whether the foundational legal principle that every American child is taught from their very first civics lesson actually means what it says. No one is above the law, not as a political slogan, not as a bumper sticker, as a live, actively contested, currently being decided legal question in a federal courtroom where a former president faces 40 felony counts, a surveillance tape of himself ordering evidence destroyed, his most trusted aide confirming Epstein connections on camera, and wiped servers whose deletion order is itself now prosecution evidence. The 45 seconds of silence in that courtroom was not just lawyers without arguments. It was an institution deciding in real time whether it was going to hold under the most intense political pressure it has faced in generations, whether the principle survives contact with the most powerful political force in contemporary American life. Every press conference can be countered with another press conference. Every social media post can be answered with another post. Evidence played in open court in front of a federal judge cannot be answered with a rally speech. The classified documents are documented. The subpoenas are dated. The destruction order is on tape. The timing is recorded. Susie Wiles confirmed the Epstein connection in her own voice. The camera recorded the order to destroy the camera footage. That single sentence explains everything about where this case now stands, and the courtroom silence told you everything about where it is heading.